Okay, Assalamualaikum warahmatullahi wabarakatuh. Welcome back to my channel. In this video, we're gonna talk about the examinations and the trial. So, in this moment, I'm gonna try to explain about how the examination and the trial of Indonesian court is conducted. So, this is actually especially for the very first stage trial in the district court for criminal court proceedings. Yeah. Uh, if we compare the Indonesian trial and the other court system, they will have many significant differences. But sometimes, maybe during the explanations, I will try to compare that to give you a comparative approach in regards to the trial. Yeah, hopefully you can get the whole idea from that, and at least you understand how the court works in the criminal court in the criminal cases. Okay, we're gonna just start. We have several types of examinations at the trial. So in the examinations at trial, we have three types, three big three big types of the examination at the trial. First is the ordinary examinations. Ordinary examination is actually the most common type that always applied to most cases in Indonesian criminal cases. So, ordinary examinations uh, applies to all type of crime except two types. First, the traffic violations, and second is misdemeanors, or we usually call it in bahasa Indonesia tindak pidana ringan. So misdemeanors, it's actually lessons. We're gonna discuss about that further. Okay, so ordinary examinations apply to everyone, and KUHAP mostly regulates about how the ordinary examinations work. So mostly, even the other types also regulated, but most regulations is about the ordinary examinations. Yeah, so when you watch, for example, Jessica cases, when you watch Antasari Asar cases, I'm speaking about the court proceeding that is actually that was published on TV, because Jessica case actually the last case that we can see live on national televisions or local televisions, because after that Aho cases we cannot see Aho case live like Jessica before, because of the regulations from the Supreme Court that is not good enough, uh, the impact. Yeah, so that is why most famous cases are ordinary examinations. Okay, besides the ordinary examinations, we have the summary, or in bahasa we usually call it as singkat, pemeriksaan singkat. Ordinary examinations we call it the biasa. Pemeriksaan singkat or summary examinations, it has the same cases as ordinary examinations, but in the summary, why the prosecutors choose summary examinations, because it's simple and straightforward. Yeah, how can we say it is simple and straightforward? Simple. The evidence are sufficient. The evidence are clear enough. So we can see the evidence is very valid. The evidences are good enough, and also mostly the defendants admit the evidences and also about the crime. So it's very simple. So the summary examination should last less than 14 uh, working days. If it is more than 14 working days, so they have to move again to the ordinary examination. So it is not simple and straightforward, because you need more than 2 weeks. Yeah, so you have to move to the ordinary examinations. The last one is express examinations. I believe most of you are aware about the express examinations. Express examination is actually uh, the examination that may apply to most people. Yeah, they usually apply in Friday on Friday. Yeah, express examinations apply to the exemptions of the ordinary examinations, which are misdemeanors and the traffic violations. Even though that traffic violation, they already established the online court system. So, for example, you haven't uh, put any seatbelt on when you drive a car, you already have the particular fines decided by the court. So it's actually more simple now. You don't have to come to the court at all. You will get the online court decisions. But still, they still have the express examinations also for the misdemeanors. Yeah, because everything that is considered as traffic violations or the misdemeanors, they still need court decision. So they will go to the express examinations only maximum 1 day, yeah, with only one single judge. That's actually the difference with the ordinary and the summary. Okay, in here, I will explain mostly about the ordinary examinations because, for example, if you talk about the moot court, national moot court competition, they usually talk about the ordinary examinations. And if you want to go to the criminal court practice, you need to understand fully about the ordinary examinations. Okay. Before that, we're going to discuss about the principles that applies to the examinations and the trial. First, it is independent because the court is actually considered as the part of the judicial authorities in Indonesia. So the judicial authorities cannot be interfered by the executive, cannot be bothered by the legislative. So it is very strong. And even for the judges, because when you talk about the prosecutors, they have the chief of prosecutor, or we usually in Indonesia as kepala kejaksaan. But in the court, you have the how call it? The coordinator, ya, ketua pengadilan negeri. So kepala kejaksaan, the head of prosecutor, this is actually different with the coordinator of the court because of what? Because every single judge, they are independent, so they cannot be influenced. For example, even you are very junior judge and you have a very different idea with the senior judge or even with the chief of the board, the judges board. Yeah, you have different idea. You can, because every judge they have on their independence. That is actually different with the prosecutors because the prosecutors you have to agree with your head of the prosecutors, even if they have the link of the coordinations, they have link of orders. Yeah, so it's not they are independent as the institutions, but not independent as the person. But in the court, every judge they have independent. The second one, they have a quick, simple, and inexpensive case. So every case should be conducted quick, simple, and inexpensive. For example, I can have the example like this. A person committed a crime in Yogyakarta, in Bantul. Yeah, Yogyakarta this day. 2 days later, he committed again in Bantul. 3 days again in Sleman. So after that in Sleman, he got caught. At that moment, how can we adjudicate that person? Those three crimes are totally independent. They are not related but committed by one person. Should they be adjudicated in each court, or Jakarta court, Sleman court, and Bantul court, differently? That is not quick, simple, and inexpensive. So that is why KUHAP also provides that we can just combine it in one place. So make it quick, simple, and inexpensive. We can have three indictments combined together, or we usually call it as fogging. Considered is actually one of the types to combine the indictment in the criminal court proceedings. Okay, so that is actually the idea. The third one is about the attendance of the defendant. So it's different with the civil law court. In the civil law, the legal counsels can represent the actual party of the case. But in criminal procedural law, it is not possible for ordinary examinations, of course, but in the express we have different. But in the ordinary examinations and the most examinations, they have to attend Yeah, even though they are not detained, they are not detained by the law enforcement. They still have to come. If they didn't come, they cannot. The court cannot start to adjudicate. Okay, the fourth one. This actually the five principles here is not only the five, but this actually the most significant for my opinion. So you have to understand. The fourth one is witnesses under the oath. So witness testimony is very strong. Is actually considered as the strong legal evidence here. So they have to be put under the oath with the several requirements. If they lie under the oath, also they have criminal charges for lying under the oath. Okay, and also the presumption of innocence. Even though that person has been detained, has been stated as a suspect in the investigations, has been put as the defendant in the court, we have to say that person is innocent until he got a binding court decisions to say that person is guilty. If there is no decisions, and if even we have the decisions, but the decision is still not binding yet, we cannot say that person is guilty. We have to say that person is innocent. Okay, so that's actually the combinations. For example, like the judges. If the judges says, "Hey, uh, do you regret that you say that you committed a crime like that?" If the judge says something like that, that already presumptions of guilt. So it's not possible. For example, if you watch the trial of Chicago Sevens, it is very clear that the judge says the persons will not be free like that. That is actually the presumption of guilt that uh, cannot be shown by any judge in any criminal court process. Okay, now we're gonna talk about steps by steps in the examinations and the trial. So, the trial will begin when the prosecutors already deliver the indictment to the court. Okay, so the head of the court, yeah, the head of the court will decide which boards, which judges, which board of the judges will adjudicate, will try this case. Okay, after that, they will have the time and the board of the judges. When they start the trial, of course, the judges need defendant to come. And the very first agenda is the indictment is read out by the prosecutors. Yeah. So it is actually according to the Criminal Procedural Code, it is compulsory that the prosecutors read out the indictment. After the indictment was read out, the judge, the head of the board, should make sure that the defendant understands at least the biggest part, like the article charge, the case, and also the consequences. At least the defendants understand about that. If the defendant is still not understand, the prosecutors are required to speak simply about the indictment. So to explain simply about the indictment. After that, the defendant will be given the right to object. So they will have the objections. This objection is totally formal. It is not in the objections you didn't talk about. I'm not guilty. I didn't do that. You are not talking about that. You are talking about the indictment, whether the indictment is good or not. Yeah. So there is at least three types of objections, three contents of objection. The first very important content, whether that the indictment is correct, it's actually right to choose the the jurisdictions of the court. It can be absolute competence and the relative competence. The absolute competence, for example, oh, this is civil law cases, or This is not this is civil law cases. This is not criminal law cases. Or you can say this is administrative cases should be in the administrative court, not this one. And that is actually the absolute competence. Or you can say, oh, this should be in Sleman court, not in Yogyakarta court. We have many theories about that. We're gonna discuss about that further. Okay, that is actually the objection. The first content. The second content will be about the formal requirements of the indictment. Yeah, whether the indictment should be accepted in the trial or should be rejected. Yeah, what are the reasons to these? For example, they can be error in persona. Error in persona can be the identity. The identity of the defendant is wrong. That actually can be one of the contexts. Or concept is the other concept is the, the formal requirements, like you don't put the correct date, the correct place, for example, because most of the cases they just copy and paste. They forget they copy the old cases, so the time is still like 2016, but actually the case is actually 2018. There are many cases like that. Even the House of Representatives can also get a typo. How about the prosecutors cannot get a typo? So typo, the error in persona, that can be the case should be rejected. Or also the indictment can be null and void. Why? Because they don't fulfill the requirements of the indictment. They have to be clear, they have to be certain, they have to be uh, they have to be completed. So they should be clear, completed, and certain. If about the cases, about the time and the place the case is conducted, they is wrong. Also, they put, for example, they get misleading explanations about the cases. For example, usually they got alternative indictment for fraud and embezzlement. Ya, tipu gelap, penipuan dan penggelapan, fraud and embezzlement, they got alternative indictment. So in the fraud, the explanation of the case like this. In the embezzlement, the explanation case like this. Usually, not usually, most cases they have just copy and paste. But actually, in the matter of the fact, in the matter of the theory, in the matter of the practice, they have to be different. Fraud and embezzlement, they have different elements, so they have to put different angle of the case. Yeah. So if they put only the same, the case, the indictment can be null and void. So that is why the objection is you don't talk about the case, whether you did the crime or not. But the lawyer can win the case only by saying that the indictment is not good enough. Yeah, we're gonna discuss about the objections further later on. Okay, if this is actually optional, the defendant can do it, or the defendants cannot do it. I just don't want to do it. Sometimes they have the strategy. We just fight in the real case, because in the real case, so you talk about the actual whether you did the crime or not. In most cases, if you say we cannot win this one, we just want to be very quick, also they just don't do it. Many cases like that. If they don't do it, they will go directly immediately to the evidentiary stage. Now we are going to say about whether when they decided to have the objections. Okay, after that, after the objections, the prosecutors will be given a right to reply the objections, or usually we call it a replic. Yeah, in here they can reply the objections. They will answer. For example, they talk about whether the Sleman court has no jurisdiction. The prosecutors will explain about the theory, about the case. So this court has the jurisdictions because of this. Or they talk about the choice of the indictment type is wrong. So the prosecutors explain about why they choose this type of the indictment. And the other thing, so they can reply the objection, so the judges will have the clarity to answer these objections. in here, yeah, they can be a verdict. They can be a verdict, the final verdict, if the objection is accepted. If the objection accepted, so the indictment can be rejected or can be null and void. It depends on the time. Yeah, that can be a final verdict or the interim verdict if the objection is rejected. Yeah, there will be a challenge, perlawanan. There will be a challenge for the interim verdict. Yeah, we're going to discuss further about that later on, but um, uh, it is very important to understand about the whole trial because the interim verdict and the objection they require more units, more SKS, yeah, to discuss about that further. We just go that interim verdict rejected the objections, so after that we will go to evidentiary process. In the evidentiary process, okay, in the evidentiary process here, they also have the structure, okay. According to Article 284, we have five types of evidence. You will have the discussions from Prof. AD and other things also in this channel about the evidentiary, but it's still bahasa. I will make it in English later on. Evidentiary, they have a witness's testimony, they have expert testimony, they have documents, they have indications, and also they have the testimony of the defendant. Okay, from these five types, of course, the witnesses should be called first. If there is a victim witnesses, the victim should give the testimony the very first time. So that is why uh, it is actually misleading of the prosecutor if the prosecutor has the victim, but the victim is not called as the very first witness. Yeah, so that is why it is actually in the kuhap also, so the victim, because we have the clarity of the case where the victim is. But sometimes, most cases, for example, like murder or accidents, we cannot call the witness because the witness sometimes died or in very bad injury. We have many cases like that. Yeah, so and then in the end, so they will call witnesses, they have the experts. In the end of the evidentiary process will be the testimony of the defendant. This is actually the difference with the other trial. For example, in US, the defendant has no responsibility to give the testimony. In Indonesia, it should be given the testimony by the defendants, but the testimony should be given by the defendant, but the defendant will not be under the oath. So you can say whatever you want as the defendant. Yeah. So that's actually the evidentiary process. After the evidentiary process, the testimony of the defendant already done. So the judges will close the evidentiary process. So the evidentiary process is done. We cannot see any more evidence. We have to move on. After that, the judge or recusitors in bahasa Indonesia surat tuntutan. Yeah, the judge and requisitor will be given here. Okay, so in here, what is actually the difference with the indictment? The indictment, you just provide several articles that is actually want to be charged to the here. In here, in the charge, the prosecutor should choose. I think this article is proven in this court. After the evidentiary process, this article is proven, and from this article, I believe from the evidentiary process, you have to get 5 years imprisonment. Yeah. So they also have the punishment asked to the court. Okay. So that is actually the judges from the case. From here, the lawyer, the legal counsels, and the defendant has the right to plead. So they have to right to give a pleading, the defense. Yeah. So this one you have the defense pleading about I didn't do it because of this. The evidence says I didn't do it. The evidence says I don't have the proof for this one. Or sometimes you also put in the pleading I have excuses to do that. I have self-defense. there is a firma and the other things. Or you can say, I have mental illness. That is also possible in the pleading. And pleading does not have the correct format, different with the indictment and the charges because they have perja, the general attorney regulations, peraturan jaksa agung, they have like something like that, so they have the format. But pleading objection, they don't have the format. You can do whatever you want. For example, like in the Ahok case, Ahok read out the speech in the court. There's actually still a good way also. In several cases, the defense asks the court and then begging the court with any word they can say without any writing statement. That's also possible. Yeah, so they have many types of pleading they can. Okay. After that, there will be a debates, replies that is unlimited. According to the Kuhab, the replic is actually the replies from the prosecutors on the pleading. So they will answer the pleading. The plea will be the replies from the defendant to the prosecutor. So it can be done whatever they want until they finish. So the judges say, okay, there is no more arguments for both sides. If there is no arguments more, the judges will stop. Okay, the examination, the whole examination is ended. Okay, so we will do the meeting. Okay, so the judges will have the meeting. The ordinary examinations, I forgot to say that the ordinary examinations should have at least three judges, but in serious cases and in some cases they have to have five judges. For example, in Jessica case we have three judges. In Ahok case, because it's very political and also public interest, they have five judges. Even though that they are same as the criminal court articles, but they have a different number of judges. That's actually possible. They have to be uh, they have to be the number. Okay, in the judges meeting, there is also the procedures that the junior judge. So the junior judge is not about the age, yeah. It's about the experience as the judges. It's about the rank in the judges and the other things. And it is also about the positions given by the head of the court in the board. Yeah. So the junior judge will provide the first opinion. The senior judge after that, and the chief of the board the last. Okay, so that's actually in that order. How if they have differences? If they have differences, first take the majority. The majority decisions will be given. First, they have to decide. They have three decisions. First, whether we have to give punishment, whether we have to dismiss the persons from all charges. Dismissal of the person of all charges is actually lepas dari segala tuntutan. Dismissal of all charges. The action is proven. The action of the defendant is proven, but it is not a criminal law case. Yeah, we were gonna talk about that longer now. And the last one is acquittance. Acquittal is actually bebas. Acquittal, you are not proven to commit those crimes. Okay. So first they have to decide which one. For example, two persons say this is acquittal, so it should be bebas. Yeah, this is acquittal, should be acquitted after that. Or uh, or they can have three different decisions. If they have three different decisions, they will have to choose the most favorable decisions. So the most favorable decisions apply if the three judges have different opinion. And after that, if for example they decide, okay, we have to give the punishment, so they will decide about how long the punishment will be according to the considerations and the other things. So the judges meeting, it's very significant also. The judges meeting is actually very important, is bound by the evidentiary process. So the evidentiary records, everything will be considered by the judges meeting, and also the indictment. The requisitor, the pleading is only additional information that they can use, but they have to follow the indictment, the evidentiary process. If the articles that judges think is actually should be given to the defendant, but there is no in the indictment, they cannot apply that. So the articles used, the case applied should be based on the indictment and the evidentiary process only. Okay, after the judges' decisions, they at the judges' meeting they will have the court decisions. Yeah, in the court decisions they will say the considerations and also the main decisions for that amar putusan. Yeah, after that they will have to wait. They have to wait for the appeal 14 days, and for the case after that the cassation 7 days according to the process and the other things. If there is no binding, if there is sorry, if there is no appeal, if there is no appeal for 14 days, so the court decision is binding, and the prosecutors should execute that examinations. Okay, so that is actually concept the whole concept of the examinations at the trial. I hope you can get it. I hope you can get the understanding of those stages. So uh, I think that will be all for today. If you have any questions, if you have anything that we have to discuss about this, you just put that in the comment. But actually, in the online session like this, it's not easy to have the class like this. For example, like now, I have this actually very late night, um, and then uh, still very difficult to have more time to have something like this. Okay, thank you. Please give any critics, comments, and other things in the comment tab. Okay, I think that will be all. Thank you. See ya.